I'm not a lawyer, but I read through all 27 pages of Brian Steele's motion for the judge in the YSL case, Judge Glanville, to be recused from the trial. And child, let me tell you what it said. Let's start at the top. It says that this is a motion to, number one, recuse or disqualify Judge Glanville from all further dealings in this case. And number two, this is a motion for a mistrial, which was brought about because of the improper conduct committed by the court, aka the judge, in concert with, or like together with, the prosecution. It talks about the ex parte meeting, saying that the judge and the state engaged in an unlawful, improper ex parte meeting with sworn witness Kenneth Copeland. Steele goes on to cite Uniform Superior Court Rule 4.1, saying, quote, judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Ex parte hearings are only authorized in the case of extraordinary matters such as temporary restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. Basically, ex parte meetings are only supposed to happen in rare and extraordinary situations. Steele then details the events of what happened, starting with him bringing to the judge's attention about the meeting, all the way through to him being held in contempt. All the while, according to Steele, the prosecutors, quote, stunningly sat mute and permitted this injustice to occur, and Steele says he declined to join the antics and instead relied on State Bar Rule of Professional Conduct 1.6, which is about attorney-client privilege, which Steele cites as saying, Rule 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. A lawyer may not disclose such information except as authorized or required by the Georgia Rules of Professional Conduct or other law. That part right there says that Brian Steele don't gotta say nothing. Steele then goes through the roles of a judge and attorneys in a trial. He says, on one hand, defense counsel is obligated to vigorously defend their clients, and prosecutors, on the other hand, must effectively and ethically present their case to a jury. At the same time, the judge is charged with ensuring that the rules of evidence and procedure are followed and that the proceedings are both orderly, ethical, and fair. Disagreements between the bench and bar are to be expected, but what's happening in this trial, Steele says, is more than just friction between zealous counsel and a diligent jurist. This judge's conduct gives the impression that he harbored an inclination to be biased against Jeffrey Williams and his counsel and partial towards the prosecution. And as a result, Brian Steele says that Glanville must recuse himself because not only do judges have to recuse themselves when there is a bias and impropriety, they also have to recuse themselves when there is even an appearance of a bias and impropriety. Here's a quote. It says, higher courts don't have to decide if an actual bias and impartiality existed because judges are required to disqualify themselves whenever their impartiality might reasonably be questioned. And so, according to Brian Steele, this ex parte meeting that the judge participated in, which was used to influence a witness to testify against Jeffrey Williams, certainly raises reasonable questions concerning the judge's partiality and bias. And simply because those questions are raised, it would be an error or wrong for the motion for recusal to be denied. Further down, Brian Steele says that the highest court, meaning the supreme one, has set forth at least 3 circumstances in which a judge must recuse himself because of an appearance of a bias, even if it's not an actual bias. First, if a judge becomes involved in a controversy with one of the litigants, they must be recused. Second, if a judge takes a role in the accusatory process, which Steele says that Glanville has done by requiring attorney Caleb Bumbus, a stand-in attorney for Kenneth Copeland, and the others to stand before him as he tries to get information about who leaked this information about the ex parte meeting. And then thirdly, a trial judge has the duty to recuse himself when their impartiality might be reasonably questioned, including instances where the judge has a personal bias or prejudice concerning a party. Steele says the court and the prosecutors should not be working together, but they are, teaming up to gain an unlawful advantage over Jeffrey Williams. This trial is constitutionally fractured, unfair, and lacks all constitutional, statutory, and ethical safeguards and protections of due process of the law. The court is biased against Jeffrey Williams and his attorneys, and no intellectually honest person could believe that coercing Kenneth Copeland to testify in a, quote, star chamber setting meets constitutional muster. This man is going in. Steele goes on to say why this motion should not lawfully be denied. He says that in a motion to disqualify or recuse, a judge is to only determine if the motion is legally sufficient. They are not to question or determine the truth of what's being alleged in the motion, nor are they to determine the good faith of the person asking for the recusal. The judge is only supposed to determine that if what is being alleged were to actually be true, would that be enough for a reasonable person to believe that there is a bias? And if the answer to that is yes, the judge is supposed to recuse himself. And if they're looking for volunteers for a reasonable person, I think I'm pretty reasonable, and there's a bias. Here it says, quote, "This court's conduct raises a strong finding that it has become personally embroiled in the case. It is clear even to a casual observer that this court's involvement in the controversy requires this court to be disqualified, recused, and or removed from further proceedings in this case immediately. And another judge who will duly exercise the powers of the judicial branch with partiality, clarity, and fairness must be appointed to this case." Still says that Judge Glanville, Ms. Love, and Ms. Hilton will all be called as witnesses at trial for the jury to understand this ex parte meeting and to determine demeanor and credibility. Additionally, they are requesting that all ex parte meetings be disclosed immediately in order to properly reveal the full extent of all violations of law and ethics. Then there's an affidavit attached from Brian Steele and Keith Adams, and I just want to highlight number 8 and number 9 in this affidavit. Number 8 says that the ex parte meeting lasted for approximately 2 hours, and during it, Kenneth Copeland was insistent that he would continue to plead the fifth on the stand, even after they told him that they were going to put him in jail. From there, Ms. Love and Ms. Hilton ignored Kenneth Copeland's insistence to not testify, telling him he would be held in custody until all 26 indicted defendants finished out their cases. And that, Brian Steele and Keith Adams say, is witness intimidation and coercion. On to number 9, which says that the judge provided Mr. Copeland with a written copy of the statute on crimes of perjury as well as false swearing. This is no subtle gesture, and one that helped the prosecution team to obtain their mission for Kenneth Copeland to change his mind and testify. Brian Steele and Keith Adams say that the judge became a member of the prosecution team when he assisted them in getting a material witness to change his mind and get on that stand and testify against Jeffrey Williams. So I'm not a lawyer, but this is wild. What y'all think gonna happen? Y'all think the motion for mistrial gonna be denied again?